somewhere where the Deputy President said, naongea kuhusu Kenya Kwanza coalition. He has been consistent. Kenya is a company and it will benefit its shareholders. So the coalition agreements that have been adduced before you are an afterthought, are just a diversion, in my view. Access documents, how did I access these documents, including accounts? I got the services of whistleblowers when people knew that I want to do this. I got the services, I got a lot of information from whistleblowers whom I do not intend to disclose their identity because they are protected under the Witness Protection Act. Honorable Kajwang, my counsel will be talking about the issue of Brobika and how it is, that particular director is related, is connected, is linked to the nexus between that particular director and His Excellency, the Gachagua. In terms of agriculture, I did admit I did not present evidence in terms of his sabotaging of the tea, much as I have information, but I leave it at that we have not presented adequate evidence in terms of sabotaging. But Kenyans would know that that role is domiciled in his office, and the price for tea has not become any better. In fact, it is still oscillating up and down. The cooperative society, I also considered, we have not presented evidence. Senator Ogwoka, the question was to the DP's legal team. Senator Omogeni, page 15, paragraph 41, whether I can tabulate, and during our closing remarks, we'll be able to...
Mutuse, conclude. Your 2 minutes actually.
We'll be at our concluding remarks, we'll be able to answer this question, but just for your information, the land acquired through Amunyoro Investments is 1.5 billion. The Abadeas, when we added, came to about 1 billion shillings. When you add Kuruitu, 250 million, and others that will be showing 412 million for Olive Gardens, they will all come to the figure that we are talking, or thereabout.
Now allow your
legal
team to respond to the questions directed to them. If at all there are any questions directed to you.
Mr. Speaker, I believe the question was about whether there has been a complaint with regard to ground 8, any report to the relevant authorities. I believe there was a related question on whether the DP has been subjected to any prosecution for money laundering or related offenses. We are not aware of any complaint under Section 132 of the Penal Code to the police or any other relevant authority. Equally, we are not aware of any prosecution that the DP has been subjected to, but in our opening and closing, we'll be showing you it is immaterial whether there has been such a complaint, whether there has been such a prosecution, because when we get there, we'll be showing you the Supreme Court has said times without number, the Court of Appeal has said times without number, that impeachment is about political hygiene, it is about political responsibility, it is not about whether there is criminal liability or whether there is civil liability, and we'll be hoping we can persuade with lots of humility that nothing turns on whether, as a matter of fact, complaints have been launched or prosecutions have ensued, and those are not my words. They are the words of our Supreme Court, as I said, not once or twice, but several times. Thank you.
The legal team of the Deputy President.
Thank you very much, Mr. Speaker. I will speak to the questions on the shareholder question. Honorable members, please permit me to answer this in omnibus, but I'll attempt to do my level best on this. The first question was, why is the President relevant in these proceedings as regards shareholders? He's relevant in two capacities, three actually. Number one, under the Constitution, the Deputy President assists the president. And so when the president tells the people of Moranga and elsewhere that they're the biggest shareholders of government, when he signs a contract that founds the government, the deputy president is bound to assist the president in moving that shareholder issue. That's number one. Number two, the Article 73, Subarticle 2, Subarticle C, Roman numeral 1, talks about honesty being a foundation principle for leadership. It is well known, I think I can say it here, my client, the deputy president, is known as the truthful man. It is pursuant to this that he is truthful. Number three, a contract and covenants in a contract must be performed if indeed any government, any contractor worthy of their name, worthy of their signature is to be believed in the future. The president, the party leaders all signed these contracts with the intention that they should be complied with. You will note that in the sections we read out for you here today, the president, the deputy president is insisting that the promises made to the people of Western Kenya should be complied with to the letter. The promises made to the people of Coast in an agreement should be complied with to the letter. Equally, all other regions that had agreements signed or promises made in these coalition agreements ought to have those promises implemented. That is the basis upon which he says it is important that we keep our words. Fourthly, the coalition agreements were in fact executed. The president and the deputy president came from UDA as the agreement said. The Speaker of the National Assembly came from Ford Kenya as promised in the agreement. The Speaker of this Honorable House and a learned friend and colleague was in fact elected as the Speaker of this House. And all the other promises that had been made were being implemented. But more importantly, as a matter of law, agreements that underpin coalition building are actually a legal consequence. They draw their force from the law. And I think Honorable Mutuse here mentioned it broadly, but I can tell you exactly where it is. Schedule 3 of the Political Parties Act requires every coalition to draw a coalition agreement. That is number one. Number two, it prescribes what is to go in that agreement. Among the things that the Political Parties Act Schedule 3 prescribes must be in the agreement is the sharing of power and responsibilities. So it's a matter of the law. And if, when the honorable members here retire, you will find that Article 108 of the Constitution delineates power in both the National Assembly and in the Senate on the basis of coalition agreements and who has the majority, who is the largest shareholder, if you will, in each of those two houses. Fourthly, or fifthly, I think it is now, I think we said this before, the deputy president had no power to appoint or implement any of those things. All he could do was speak to the agreements that had been signed by the party leaders, and that's all he was doing. He was expressing what was in the agreements and saying we ought to keep our word, we ought to do what we promised in these documents which we filed at the Registrar of Political Parties. Sixthly, in the statements that were read to you in the videos, there are two things to note. Number one, the deputy president is talking about government. He's very clear. He doesn't say the nation. He doesn't say the national cake. He doesn't say resources. He says, just to read for you one example, at page 6 of 85, a government is like a company, government. He's not talking about resources, he's talking about government, and that's all it was. It is important for members to remember, to recall, that these provisions of the law I am sharing with you here followed the famous, or should I say infamous, NAC MOU, which became very litigious. I had the privilege of participating in that case. The famous NAC MOU was set aside because it had no anchoring in law. That was corrected, and that is what these agreements are about. Seventhly, and I think I'll combine this with, although I'll come back to that later, but the Deputy President, in the videos, when you listen to them correctly, says the President needs to work with people who believe in his policy, who believe in his manifesto, who will implement what he had in mind when he campaigned on a specific platform. That's all he's saying. And it's very simple. If you don't believe in my policies, if you don't believe in my manifesto, how are you going to be the one I appoint to implement that? It wasn't about tribes. It was about manifesto, it was about policy, it was about specific issues set out in agreements. Now, political rhetoric might use certain words. Politicians use all manner of words. The party I represented in the last election was called Mganga many times in the campaign trail. But we know he's not a Mganga, you know? So, but it's political talk. Number 8, these agreements were not limited to Kenya Kwanza, as I said, because they're part of the law. The government that preceded Kenya Kwanza, Jubilee, had similar agreements deposited with the Registrar of Political Parties. Azimio la Umoja, One Kenya, had a similar agreement. It's only that they never got to power, but they had a similar agreement. And the reason for this is that even internationally, these agreements are known as power-sharing agreements. There's no magic to it. That's what elections are about the division of power. That's what it is about. And because of that, these agreements, in fact, do the opposite of what Honorable Mutuse is saying they did. He says they cause disunity. In fact, they are a source of unity when the diverse sectors of the Kenyan society can get together. For example, Kenya Kwanza, I think, had 16 or so parties. Azimio had 25. The different characteristics of Kenyan society are captured in all those parties. That's what coalition building is all about. And it not only works at national level, even at the devolved level, we have what are called negotiated democracy agreements, like these ones, which take into account clans and that sort of thing. Now, my good and learned friend, Mr. Sifuna, asked a question about what happens to the others who are not mentioned in these agreements. We have a practical example. Members of his party, ODM, are now in government. The party, the contracts left room for accommodation. My good friend,
Order. You cannot raise a point of order on the council. You cannot. Council, you have 3 minutes to conclude.
Thank you. I just wanted to set the point that the agreements were dynamic, that politics is dynamic, that these things have a way of settling themselves, and they do. The next point I wish to say, I cannot say, I think he asked me the question about, for example, the constitution requiring PSs and others to be advertised. I cannot speak to how Kenya Kwanza intended to implement that, but like I've demonstrated, it was implemented. They found a way to do it. I don't know how they did it, but we're just speaking to what they did. Honorable Stuart Mazayo asked a question about Chakula Kikiva. You will note that a lot of the videos that were played here today were made in Nandi or in Kericho. There was a very specific reason for that, and the Deputy President himself will be addressing that question today. The only other thing I can tell you about those videos is that whenever the Deputy President raises that question, either in Nandi or in Kericho, he is cheered wildly. It is a very popular issue in those two counties. Finally, I think to a question that was asked about how Honorable Mutuse and others would feel, even regions that did not overwhelmingly vote for Kenya Kwanza, including, for example, Machakos, Makueni, and Kitui, actually got 2 cabinet secretaries in the cabinet in the fullness of time. And so no one was actually discriminated against. This was not about tribes. I think the confusion has been brought about by Mutuse's motion. This was about sharing of government and those who believed in the policies of this government. I hope I have attempted to address all the questions you have raised.
Conclude by responding to Senator Olekina's
Yes.
consent issue.
Sorry, Your
Consent
Senator.
issue.
If you could remind me the question, I'm sorry.
The consent.
Oh, it's. The consent is being addressed by my good and learned friend,
Very
Mr.
well,
Elisha
very well.
Boya.
Yes, Council.
Thank you, Mr. Speaker, and thank you, distinguished senators. The distinguished senator for Narok County has asked succinct questions. Number one, if you look at the petition claimed two things. That number one, the Deputy Chief Justice has no respect for the judiciary, which is why he made the allegations that he made against Justice Esther Maina. And number two, that the the Deputy President, my apologies, lied when he said he was going to file a complaint before the JSC. So you respond to the motion as presented. Now, to respond to that, there was no necessity to file this consent because the consent does not address itself to the claim by the DP that is going to file a complaint against the judge. What had then happened, distinguished senator, is that the witness came here and then began taking this court through the judgment of Maina. Now it's altering the claim as presented in the motion, which is why we had now to take him through the issue of the consent. Now that addresses, and so we have not presented the consent before this Senate because the motion as framed did not require the consent to respond to it. But having said that, my learned colleague, the mover of the motion, makes a false statement that a consent does not determine the merits of the matter. In fact, a consent determines the merits of the matter. When you enter a consent and say that the judgment that was rendered by the trial court, you are entering a consent to state a different state of affairs. You are actually vacating that judgment. The trial court had taken the money in question from the DP to the Asset Recovery Agency. The consent took the money from the Asset Recovery Agency back to the DP. That is the substance of the matter. So the argument by the mover of the motion before you that a consent does not settle the matter on the merits is law upside down. Law upright is that a consent settles the merits of the matter that it addresses. Thank you so much.
Now, honorable senators, can I get an indication from Council for the National Assembly? How many witnesses do you intend to call beyond Honorable Mutuse?
Mr. Speaker, we have 3 more witnesses, and while on it, at the point we stopped examining the Honorable Mutuse, you said we had 45 minutes.
Yes, you have.
But when I went there, you said 40, so we were a bit alarmed.
No, you have 45 minutes.
Much obliged.
And the team for the Deputy President, you've exhausted your time, but there was 10 minutes that has been occasioned by the technicality on the videos. So you need to utilize that with the remaining 3 witnesses. Now, honorable senators, Honorable Mutuse is not going to leave. You're going to stay on as we hear the 3 witnesses, and then if the other clarifications that honorable senators wish to direct to you, please be available. Kindly usher in the second witness.